Hi, welcome to CLAT chat. Actually, in the last class, I explained you about the means notes on Maneka Gandhi versus Union of India. So actually, these cases means all the familiar cases and notes on familiar cases is very much useful to the aspirants of civil service examination as well as AoR examination and as well as that is means CLAT examination also. CLAT examination also. So here you have to know how to write the notes on familiar cases as well as you have to know that how to write the notes in brief as well as in detail. Depends on the marks given to that question. This is very much important because you cannot follow the same rule for the both. As well as in every class I am explaining you that to write a note on familiar case, you have to observe 5 things which are very much essential. First one is facts of that case. Second one, issues in that case. And third one is arguments of the petitioner or petitioners. And the fourth one is arguments of the respondent or respondents. As well as the final one and the fifth one is judgment. These 5 you have to observe and you have to trace out from that case and you have to give the notes on each topic elaborately or in brief as per the need. Today I am explaining you about one of the important case, that is Minerva Mills versus Union of India. You know that it is very important case and also very difficult in understanding because in this case dates are very much important. In other cases dates are not an issue because all are in the proper way, but in this case dates are very much important. So I am coming to the case. Today I will explain you about this Minerva Mills versus Union of India. Facts of this case are Minerva Mills is a limited company owned textile undertaking in Bangalore, that is in the state of Karnataka. In fact, this industry violated some of the norms prescribed by the government of India. Prescribed by the government of India, as mentioned in the Industries Development and Regulation Act 1951. In the matter of production. In the matter of production, that is very important. When it came to the notice of the Union of India that this company, this industry violated some norms prescribed by the Union of India, the Union of India appointed a committee under section 15 of Industries Development and Regulation Act 1951 to submit a report to the Union of India about this industry. Based on this report submitted by the company to the Union of India, the Union of India passed the order on 1910-1971 under section 18A of Industries Development and Regulation Act 1971. The order is that it is directed to the National Textile Corporation Limited to take over the Minerva Mills. After that, As per the Act of Sikh Textiles Undertakings Nationalization Act 1974, this industry was nationalized. This industry was nationalized. These are the facts of the case. Aggrieved by the action of the Union of India, means action of the order passed by the Union of India dated 1910-1971, as well as some of the sections in Sikh Textiles Undertakings Nationalization Act 1974, the petitioner, that is Minerva Mills, filed the writ petition wide number WP Civil 356 of 1977 in the Honorable Supreme Court of India. These are the facts of the case. But already I told you, in this case, dates are very much important. Why? Because you see, order passed by the Union of India is on 1910-1971. 1971. As well as Sikh Textiles Undertakings Nationalization Act come into the force in 1974. In 1974. But the writ petition was filed in the year 1977. See, three different dates and in different years. Here, whether there is means the Limitation Act is applicable to this case or not is also important. Limitation is not applicable to this case because it is a writ petition. In writ petition, limitation is not essential. Not essential. So, even though the order passed in 1971 and the Sikh Textiles Industry and the Sikh Textile Undertakings Nationalization Act 1974 come into the force in 1974, and even though it was challenged in 1977, there is no question on limitation. There is no question on limitation. But here, what are the issues? That is very much important. You see, the issues are that is different. Means in 1977, the Minerva Mills filed the writ petition in the Supreme Court. But in 1977, there was an amendment to the Constitution in the name of 42nd Amendment. In the name of 42nd Amendment, it is also called as the Constitutional Act. The Constitutional Act. So, here, after the means the 42nd Amendment come into the force, the Minerva Mills filed this writ petition. So, the issues in this case are, first one, they challenged the order passed by the Union of India in 1971, as well as they challenged some of the sections in the Sikh Textiles Undertaking Nationalization Act 1974, and also the means the Minerva Mills challenged another two. Those are the validity of Section 4 and Section 55 in 42nd Amendment. Why? Because here, what is this amendment to Article 31C by Section 4 means? Previously means prior to the amendment made by Section 4 of 42nd Amendment, it was there as the principles subscribed in Clause B or Clause C. Clause B or in Clause C. But it was amended by Section 4 of 42nd Amendment as all or any principles prescribed in Part 4. Part 4. As well as the amendment made to the section 50 means article 368 by section 55 of 42nd amendment, the action of the state cannot be challenged before any court of law, including the fundamental rights. So, all these four are challenged in the Minerva Mills case, which is a batch case. Means it is not a single case. N number of cases bring as one batch and decided as batch case. So now the issues are in this batch case are, first one, that is the order passed by the Union of India on 1910-1971, as well as some of the sections in the Act Sikh Textiles Undertaking Nationalization Act 1974, as well as the validity of section 4 of 42nd amendment and section 55 of 42nd amendment. These four are the issues in this case. Now coming to the arguments of the petitioner. What are the arguments of the petitioner means? See here, the arguments of the petitioner is that part 4 versus part 3. Part 4 versus part 3 means the section 4 as well as section 55 of 42nd amendment overriding the fundamental rights granted to the petitioner by Article 19. You know that according to Article 19G, right to business is a fundamental right. And the arguments of the respondents in this case are, whatever the action of the state under the part 4 are only in the interest of the public interest. So there shall not be any judicial review. These are the arguments of the respondents in this case. Upon hearing the both sides, Supreme Court passed a tremendous judgment. First one, Supreme Court declined to interfere in the matter of order passed by the Union of India on 1910-1971. Second one, Supreme Court declined to interfere in this matter of challenging some of the sections in Sikh Textile Undertakings Nationalization Act 1974. But Supreme Court passed the judgment related to section 4 and section 55 of 42nd amendment. Supreme Court ruled that section 4 and section 55 of 42nd amendment are invalid and unconstitutional. Because according to the judgment passed by the Supreme Court, even though the Parliament has no power to amend the basic structure of the Constitution of India. Means even the Parliament cannot override the fundamental rights granted to the citizens by the Constitution of India. This is the case. Due to this case, explained about the powers of Parliament related to the amendment of basic structure of the Constitution, this case became very familiar. very familiar. Once again, I will repeat the important points in this case. Brief facts of the case are: Minerva Mills is a limited company owned textile undertaking in Bangalore. Due to there is some violation by this industry, means this industry violated some of the norms prescribed by the Union of India in the Act, Industries Development Regulation Act 1951. The Union of India appointed one committee to submit a report to the Union of India about this industry related to its productivity, means production. Based on the report submitted by the committee, based on the powers conferred to the Union of India under Section 18A of Industries Development and Regulation Act 1951, on 1910-1971, the Union of India passed an order directing the National Textile Corporation Limited to take over the industry. Later on, it was nationalized in 1974 according to the Sikh Textiles Undertakings Nationalization Act. Aggrieved by the order passed by the Union of India, as well as some of the sections in this Sikh Textiles Undertaking Nationalization Act 1974, the petitioner Minerva Mills filed writ petition wide number WP Civil 356 of 1977 in the Supreme Court of India. But before filing of this case, the Union of India brought the act in the name of the Constitutional Act, that is 42nd Amendment, and according to this act, there is an amendment in Article 31C by Section 4 of 42nd Amendment, as well as there is an amendment in Article 368 by Section 55 of 42nd Amendment. According to this amendment, whatever the action of the state under the Part 4 of the Constitution of India, it cannot be challenged before any court of law, including fundamental rights. The arguments of the petitioner are: Section 14 means both the amendments made to the Article 31C by Section 4 of 42nd Amendment, as well as Section 55 of 42nd Amendment, means related to the amendment of Article 368, both are overriding the fundamental rights granted to the petitioner under Article 19. Because right to business or right to trade is fundamental right according to Article 19G. But the arguments of the respondents are: whatever the action of the state under Part 4 of the Constitution of India, it is only in the interest of the public. Therefore, it cannot be challenged, means there is no chance for the judicial review related to the action under Part 4 of the Constitution of India. Upon hearing both the arguments, Supreme Court declined to interfere in the matter of order passed by the Union of India dated 1910-1971, as well as related means validity of the some of the sections in Sikh Textiles Undertakings Nationalization Act 1974. But Supreme Court ruled that Section 4 as well as Section 55 of the Constitution Act or 42nd Amendment are illegal and unconstitutional. So, according to the judgment passed by the Supreme Court in this Minerva Mills versus Union of India, even though the Parliament has no power to amend the basic structure of the Constitution of India. This is the notes as well as the details about the Minerva Mills versus Union of India. I will explain you some of the other important case in the next class, that next Friday at 8 p.m. Till then, bye and all the best.